Hello, I'm Karen Friebe. I'm the head of Bird and Bird's International Hotels, Hospitality and Leisure team. Today I'm going to be in conversation with Alison Dixon, who's a partner in our international employment team, about the latest developments in employment law insofar as they impact the hospitality sector. So Alison, there's a lot of change happening in UK employment law at the moment, and the impact on employers, including hospitality employers, is going to be really quite significant. So what's actually happening?
Hi, Karen. Yeah, so there have been some recent changes to the law on sexual harassment that create additional prevention duties for UK employers. And then, in line with their pre-election promise, the Labour government are going to pass a raft of new legislation which will come into effect over the next couple of years, all with the aim of increasing protection for workers. That obviously means increasing compliance and an increased cost burden for employers. Most of the changes are in the Employment Rights Bill, which is going through Parliament at the moment and is not yet in final form. So we don't have the complete picture, but it is clear even now that there will be a lot of change.
So, Alison, perhaps we should look at the duty to prevent sexual harassment first, since that's already in force. And so presumably hospitality employers need to be taking action now if they haven't already done so.
Yeah, absolutely. So just to summarise, some legislation came into force on the 26th of October 2024, amending the UK's Equality Act 2010. And they amend it to introduce a positive duty requiring employers to take reasonable steps to prevent the sexual harassment of their employees. And that's on top of existing rules in the Equality Act, which already made employers vicariously liable for unlawful harassment committed by their employees in the course of their employment. The difference with this new duty is that it's an anticipatory one. So employers have to take proactive steps to prevent sexual harassment before it occurs. And the regulator responsible for enforcing this duty, the Equality and Human Rights Commission, or EHRC for short, has confirmed that this duty applies not only to the prevention of sexual harassment of employees by fellow employees, but also harassment of employees by third parties, such as customers. And if an employer fails to take reasonable steps to prevent harassment, then that can result in increased compensation to a claimant that brings a claim for sexual harassment against the employer of up to 25%. And the EHRC has enforcement powers independent of any employee complaint.
So what should hospitality employers be doing to comply with this new duty?
Well, helpfully, the EHRC has produced an 8-step guide for employers to follow. And so taking the steps in that guide should really help employers to show that they have taken reasonable steps to prevent. And the guide recommends that first, employers develop a comprehensive and effective anti-harassment policy. So establish and communicate a clear policy that defines unacceptable behaviour and outlines the reporting and response procedures that are in place. Second, staff need to be engaged. So an employer needs to make sure staff are aware of the policy, that they understand what the consequences are of breaching it, and also that they understand how they can report sexual harassment. Third, conducting risk assessments. So that involves looking at the workplace and determining any particular risk factors and how they can be mitigated. So risk factors might include things like night work, regular lone working, consumption of alcohol in the workplace, or particular power imbalances in the workforce. Fourth, the EHRC recommends that employers encourage and facilitate reporting. So employers need to create safe, confidential and accessible reporting mechanisms and, importantly, keep centralised records of complaints. And that helps them to identify hotspots or problem areas and therefore feeds back into the risk assessment. Fifth, employers should raise awareness and train their staff. So providing regular training and resources to educate employees about harassment and prevention strategies is absolutely central. Sixth, obviously, responding effectively to complaints. Complaints need to be investigated promptly and appropriate action taken where sexual harassment is found to have occurred. Seventh, dealing with harassment by third parties. So third-party harassment should be included in risk assessments and covered off in an employer's policy. And also, reporting processes should cover third-party harassment as well. Finally, employers need to monitor and evaluate their actions. They need to regularly look at the effectiveness of the steps that they're taking and make changes that arise from that evaluation. So reviewing complaints data, engaging in staff surveys, and holding lessons learned reviews after complaints are resolved will all help ensure that the employer has taken and is taking reasonable steps to prevent sexual harassment.
Alison, I expect employers in the hospitality sector will be particularly concerned about third-party harassment and the nature of some of the work that makes staff in that sector particularly vulnerable to harassment. What kind of measures are you recommending for this particular sector?
I think the first thing to remember is that the duty is to take reasonable steps, not all steps. And as I said, the steps that you can take that are reasonable, where you're talking about third parties, are likely to be less onerous than the steps that you can take in relation to your own workforce, where you have much more control. But I think some of the steps hospitality employers consider are having enhanced and tailored training for staff that focuses on scenarios that are specific to the employer and to the sector and are particularly focused on customer interactions, I think. Second, robust reporting mechanisms should be put in place with emphasis that third-party harassment is covered by these and should be reported to the employer so that it can take appropriate steps. Good manager and supervisor training is really important in this sector. These people will likely be the first port of call for reports of third-party harassment, and they will need to have the skills to manage those reports, potentially intervene in difficult situations and provide immediate support to affected employees. Displaying notices that clearly state that the business has a zero tolerance approach to harassment and reserving the right to refuse service to customers who engage in harassment of their staff is one thing that can be done, and reporting incidents that do occur to the police where it's appropriate. Finally, I think really examining the physical working environment is important. Are employers providing staff with somewhere private to go that they can easily access in the event that they have difficulties with a customer? Are workers able to commute safely, especially where they're starting and finishing work late at night? And are there appropriate surveillance facilities on the premises? Those are all things I think that could be relevant to this particular sector.
That does sound like a lot to take on board. So where would you suggest an employer starts with all this?
I think the starting point has to be the risk assessment, because that's the comprehensive look at the whole working environment and an assessment of your policies and reporting processes, the training you provide to staff and management, and the working environment more generally. The risk assessment should then help an employer to drive and determine what steps they need to take specifically to reduce the risks that they've identified. So I think that should be the starting point, really. Carry out your risk assessment and go from there. And just to add that the Labour government has committed in its Employment Rights Bill to extending this duty to prevent. So it will require employers to take all reasonable steps to prevent sexual harassment rather than just reasonable steps, which clearly places a more onerous duty to do everything that's reasonably possible to prevent sexual harassment. And the bill will also introduce specific rules making employers legally liable for the harassment of their employees by third parties, where the employer has failed to take reasonable steps to prevent. So the direction of travel is definitely towards more onerous obligations here, and employers should definitely be looking at this area very carefully, starting with sexual harassment, but with half an eye on the fact that preventing unlawful harassment of all kinds is going to be a high priority in due course.
Thanks, Alison. You mentioned the Employment Rights Bill, and there's clearly been a lot of publicity given to the Labour government's plans to overhaul employment law. I understand that it's a huge piece of legislation, though, covering a lot of different aspects of employment law, and I expect that employers may be feeling quite overwhelmed by what's coming down the track. What do you think are the key changes that hospitality employers should be focusing on and planning for?
You're absolutely right that there is a huge amount of change in the pipeline in lots of different areas, including family-related rights. For example, they're going to make parental leave a day one right. They're going to give people returning from certain types of parental leave enhanced protection against dismissal. They're going to give greater rights to trade unions, impose enhanced pay gap reporting obligations, require employers to publish menopause action plans, and extend time limits for employment tribunal claims. And the list goes on. But I think three of the most radical changes for employers in hospitality are going to be the changes to unfair dismissal rules that give enhanced legal rights to a swathe of employees that don't currently have them. Changes to rules on fire and rehire, which will make it a lot harder for employers to make changes to their employees' terms of employment, and additional protection for workers on 0 or low hours contracts.
So, Alison, what's happening with unfair dismissal rules?
So basically, the Employment Rights Bill will remove the 2-year qualifying period for unfair dismissal claims. At the moment, once an employee has 2 years' service, their employer can only lawfully dismiss them if they have a fair reason, and those fair reasons are conduct, capability, redundancy, illegality, or some other substantial reason. And they also have to follow a fair process in arriving at that decision to dismiss. In the first 2 years of employment, those rules don't currently apply. So employers have a lot more flexibility in practice to part ways with an employee during that first 2-year period. Once the new law comes into effect, all employees will have the right not to be unfairly dismissed from day one in their role, meaning that the current flexibility is more or less gone. There is one caveat to that, which is that the bill introduces this new concept of an initial period of employment, and that will function as a sort of statutory probationary period. During that initial period of employment, the government has said that employers will be able to follow a less onerous process to dismiss employees for conduct, capability, illegality, or some other substantial reason.
So do we know yet what this less onerous process will be?
No, we don't know yet. We expect that it will involve the employer having to hold a meeting with the employee to explain the concerns that they have, at which the employee will have a right to be accompanied by a trade union rep or a colleague before implementing a dismissal. But specific details of that proposed process have not yet been published. And we also don't know for certain how long the initial period of employment during which this kind of lighter touch process will apply is going to be, although the indications are that the government wants to go for 9 months.
Oh, so it seems that change will have a big impact on how employers handle terminations during the very early stages of employment.
Yeah, and it seems likely to impact hospitality employers in particular, where staff turnover is traditionally quite high in many areas. And consequently, this sector has benefited from the significant flexibility that currently applies during those first 2 years of employment.
Well, it certainly has. So what should employers be doing to prepare?
First thing to say is that this change is not going to come into force before the autumn of 2026. So there is still a way to go, and we don't have all of the details yet, as I've said. So it's probably too early to try and make changes to employment contracts, for example, or procedures. But things for employers to start thinking about now might be whether they can or should start adopting a more cautious approach to hiring. That may well be one of the key consequences of the change, which is that employers slow down their hiring and really scrutinise requests for new headcount. Second, I think it's worth examining now whether recruitment processes are robust and effective. Are employers properly assessing candidate suitability at the hiring stage so that they're hiring the right people in the first place and reducing their risk that they're going to be looking at potential terminations down the line? And finally, I think probation and performance review practices can be looked at now. Employers can think about how they effectively monitor performance during the initial period and make sure that managers are trained properly in handling performance issues. The day one right to claim unfair dismissal will mean that employers will have to show that they have a good and potentially fair reason for dismissing. And in the performance context, that will mean showing that performance has been properly measured and reviewed, and that where there has been underperformance, it's been properly managed before a dismissal decision has been made. So there are a few things employers can be starting to do in anticipation of these changes, even though we don't yet have full clarity.
So what else is on the potential to-do list? You mentioned fire and rehire. Can you remind me, please, what this means and what the government is planning to do?
Yeah, of course. So fire and rehire is shorthand for changing employment terms by dismissing an employee and offering to re-engage them on amended terms. Typically, that happens when consent can't be obtained to a detrimental change to an employee's terms of employment. And there's a related concept of fire and replace, which refers to dismissing employees and hiring replacement staff, again on less favourable terms. At the moment, those practices are lawful in the sense that it is possible to fairly dismiss someone for refusing to agree new terms of employment, as long as a fair process is followed and there's a genuine business reason for wanting to make the change. There's a code of practice covering fire and rehire, which largely encourages fair negotiation and suggests that dismissal should be a last resort. But the government is planning to really tighten up the law in this area.
So how are they planning to do that?
So essentially, the Employment Rights Bill will make it automatically unfair for an employer to dismiss employees for refusing to agree changes in terms or to replace them with another employee on varied terms. There will be an exception, but it is very narrowly drafted. So it will only be potentially fair to dismiss someone in this scenario where an employer can show that it has an unavoidable need to make the proposed changes because it's in financial difficulties that affect the business's viability, and the changes are needed to eliminate, significantly reduce, or mitigate the effects of those difficulties. So unless as an employer you can show that you're having severe financial problems and you need to make changes to employees' terms to essentially eliminate or mitigate those, you will not be able to dismiss someone fairly for refusing to agree to a change in their terms.
So what will this narrowing down mean in practice, do you think?
Well, it will really limit employers' ability to make changes to employees' terms unless the employees are supportive of those changes. So employees will have a lot more leverage in any negotiations around changes to their terms of employment. And although fire and rehire is already controversial, employers do currently benefit from a lot of legal flexibility here, and that will just be severely reduced once these changes are in force. Hospitality employers may struggle in particular, as the nature of a lot of businesses in this sector means that there is fluctuating demand for their services. Staffing requirements can frequently change, and they rely on being agile in terms of the numbers of employees that they have and the terms that they're employed on.
When will these changes come into force? And is there anything that employers can or should be doing to prepare for them in the interim?
We don't know exactly when they'll become law, but it could be as soon as the Employment Rights Bill is passed into law, which could well be later this year. I expect some employers may be trying to get ahead of this change by trying to implement any changes that they already know they want or need to make ahead of the law coming into force. But any employers that are trying to do that will need to proceed with caution. As I have said, fire and rehire is controversial already and very newsworthy, and efforts to push through changes in this way ahead of a change in the law may be particularly damaging to an employer's reputation and brand. One perhaps unintended consequence of this strict new law is that we may actually see more redundancies. So an employer who might, under the current regime, have tried to agree changes to existing employees' terms as a cost-saving measure and may have a compelling business reason for it, they may not be able to show that they're having financial difficulties affecting their viability so as to justify the change under the new law. And that may mean that they may prefer to avoid trying to agree changes to terms altogether and instead seek to reduce their costs via redundancy, headcount reduction. We might also see employers overhauling their employment contracts in an attempt to try and build in flexibility, so including clauses that allow them to make certain changes to employees' working conditions unilaterally. But there are limits on the enforceability of clauses of that type, and these are likely to be challenged, so any drafting would need to be really quite carefully looked at.
Okay, so there's a bit of time to play with here, but employers really do need to keep an eye on the progress of the legislation and watch out for further information on when the changes are likely to come into force. The last set of changes you mentioned, Alison, relating to 0 hours workers, they sound as though they'll be particularly relevant for hospitality employers, as many in this sector tend to use these contracts to deal with fluctuations in demand and to provide flexibility. So what's the government planning for them?
So these are probably some of the most complicated changes in the Employment Rights Bill, and there is still a lot to be clarified in draft regulations. So it's early days on this one. But in summary, the bill introduces 3 key obligations for employers who engage workers on 0 hours contracts or minimum hours contracts. So contracts that do not guarantee any hours or which guarantee only a minimal number of hours per week. So first of all, the law will require employers to monitor the working patterns of these categories of worker and offer them a contract with guaranteed hours that reflect the actual working pattern of the worker over a reference period if it involves working more than the guaranteed minimum in their contract. Secondly, employers will be required to give reasonable notice of the cancellation of a shift or a change to a shift to be worked by these categories of worker. And the notice of cancellation will not be reasonable if it's shorter than the duration of the shift that was going to be worked. Notice of changes to the start or end time of a shift will also be subject to minimum requirements, and there will be compensation available where an employer fails to comply with this obligation. And finally, workers will be entitled to compensation where their shifts are cancelled, changed, or curtailed at short notice. And the government has recently just confirmed that these rules are going to extend to agency workers as well as directly engaged staff. And the idea of that is to prevent avoidance by just simply moving to an agency model. So there's a lot still to be worked out on these changes, including what the minimum guaranteed hours will be for someone to qualify for these rights, what the reference period will be for measuring someone's actual working pattern, the formalities for the offer of a contract with guaranteed hours, how much notice is going to be required for cancelling or curtailing shifts, and how much compensation will be payable. So still a lot to be determined, and the impact will obviously depend quite heavily on some of these variables that have not yet been clarified.
That all sounds pretty complicated and administratively burdensome, if I may say so. What's the timing for these changes?
Yeah, agreed that the draft rules are extremely complex and the compliance burden will be big. There will be a lot of work for hospitality employers in managing the admin associated with complying these rules, so additional costs associated with that. And seasonal fluctuations in demand in this sector may mean that employers find themselves having to offer guaranteed hours based on a working pattern at a busy time of year, for example, the summer holidays, that is not sustainable over less busy periods. So there's a real question mark about how this is going to work in practice. The good news is that the rules are unlikely to come into effect before 2026, and we should get more clarity on how they're going to work in practice in the coming months with the publication of the draft regulations. But the bad news for employers at this point is that there is unlikely to be too much in the way of dilution of these proposed rules before they come into force, unless something drastic happens in the next few months.
There really is a lot for businesses to get to grips with here, isn't there?
Yep. And we've only covered a few of the planned changes here. Because there's so much going on, I think it can be really hard for employers to know where to start. I think it's important to remember there is still time to prepare. And a lot remains uncertain, but businesses in this sector really do need to keep track on what's coming, because there is no getting around the fact that the UK employment law regime is going to look quite different in a couple of years' time.
Alison, thank you very much for that very comprehensive and detailed summary of what's coming down the line in employment terms for employers and employees in the hospitality sector. Thank you to everyone for listening into this podcast. Alison and I will do another as things start to progress in this area, so please do listen out for news of our update. Thank you very much.